As I write this, the court has not yet handed down its decisions in these two cases. Robert George told me when we talked that there were a few intriguing moments when the court heard the arguments for the cases.
There was one surprise, which is that Justice Sotomayor, who is a liberal jurist appointed by President Obama to the Supreme Court, former judge on the United States Court of Appeals for the Second Circuit, who had a very liberal record on that court, asked a very tough question to those who are arguing that the Equal Protection Clause of the 14th Amendment requires states to recognize same-sex partnerships as marriages. She asked the question, well, if that's true, then on what ground of principle could we say that states are permitted to refuse to recognize polygamous marriages as valid? It was a penetrating and tough question. One would have expected it from Justice Scalia, perhaps, or Justice Alito, but not from Justice Sotomayor. And to her very great credit, she asked the question, and the answer was not a very good answer.
Now, I want to move away from the jurisprudential questions and get to the first few chapters of your book. And really, this is a case, and I feel a little bit like Bill Clinton. This is all about what the word "is" means. And I mean, this is about what marriage is, not what same-sex marriage is. You make that very clear. And at the risk of sounding naive, I've wondered for a long time why the same-sex marriage arguments have been seen as plausibly a civil rights argument, because there is nothing in any laws that prevent homosexuals or lesbians from being married as long as they marry people of opposite sexes.
Yes, that's right, and there's even more to the picture than that, as my co-author Ryan Anderson has very frequently pointed out in the public media. It's wrong to speak of there being a, quote, ban, unquote, on same-sex marriages. When we speak of a ban, we normally mean that there's a legal prohibition and that someone can be punished for committing an act. So, for example, there is a ban on bigamy. If a man is married and he goes through a marriage ceremony with a second woman without being divorced from the first woman, he will very likely be convicted and go to jail. Certainly if he's caught, that's likely to happen. There's a ban on bigamy, but there is no ban on same-sex marriages. If you regard your relationship as a marriage, you can go through a ceremony. There are churches that will perform these, liberal churches that will perform these so-called wedding ceremonies and recognize within their communities these relationships as marriages. You can get benefits from companies who are employers who recognize same-sex partnerships as marriages or the equivalent. There's no ban. There's no prohibition. The question is not whether these relationships will be banned or prohibited. They won't be. The question is whether they will be recognized as marriages, whether the law will recognize these partnerships as marriages.
And that means that the law would not only mean that the state would recognize, that governmental agencies would recognize these as marriages, but that all third parties would be compelled to recognize them as marriages.
Yes, with very narrow exceptions, typically in legislation that redefines marriage in order to accommodate same-sex partnerships. There will be a so-called protection. It's so minimal that one hesitates even to call it a protection of clergy, so that they won't be required to perform same-sex weddings. However, beyond that, there's typically very little protection indeed. So churches in their hiring, for example, for school teaching, people who play various roles in the churches or in religious education or in the music ministry, who were in same-sex legally recognized marriages, would be in a position to, in effect, require churches to treat them as married. Mm-hmm. So yes, I mean, this doesn't simply affect the two people who are involved. It affects the much broader community.
And another question I have is, would there be protection if, for instance, I taught at a Christian school? Would I be able to teach a view of marriage that reflects the traditional conjugal understanding, and say that no matter what the state says, these other arrangements really aren't marriage?
Well, I mean, that's to be determined, and I don't think the prospects in the long run for any protection there for churches and religious organizations are very good. Mm-hmm. I think it's very likely that religious liberty here will simply be regarded as a claim of a right to discriminate, and we don't honor the right to discriminate in this country. When we regard people as racists, well, we don't put them in jail, but we impose lots of other civil disabilities on their institutions when it comes to areas such as licensing, accreditation, for example, of educational institutions, and government contracting. So lots of pressures will be brought to bear against institutions that refuse to go along with the new morality and this revised understanding or redefinition of marriage.
And so I think one of the points here is that this does not expand the freedom to define marriage any way we want to. This, if the trajectory continues, this amounts to the state saying there's only one definition of marriage. It's this revisionist understanding, and I want to have you summarize that for us in a minute.
Well, yes, Ken, you've hit a very, very important point here. A lot of people seem to fall for this idea that what was being advocated was neutrality between competing conceptions of marriage. The idea being the state, well, shouldn't take a position. It should just be neutral between different ideas, people's own individual ideas of what counts as marriage. But that is false. That's not what's happening. It's not true. There's no real possibility of neutrality in this area. Government is going to endorse one understanding of marriage over another unless it simply gets out of the legal recognition of marriages altogether and treats them like baptisms or bar mitzvahs, which some libertarians want to do, but there are very good reasons, which we can go into if you like, why that would be a bad idea. But since the law is going to recognize some relationships as marital and other relationships as not marital, it will embody a non-neutral, a very definite non-neutral understanding of marriage. Historically, that understanding of marriage has been the conjugal understanding of marriage, as the union of husband and wife. And marriage has been understood as a relationship that is oriented toward and would naturally be fulfilled by having and rearing children together. Marriage was the institution that binds men to women as husband and wife to be mother and father to any children that are born of that union. And that's obviously enormous social importance and social value. What is being proposed by those who would redefine marriage is a very different understanding of marriage, not neutral, one that understands marriage essentially as sexual romantic companionship or domestic partnership, different from other sorts of relationships, non-marital relationships, not because they're different in kind, they're different kinds of things, but only in degree of emotional intensity. So your marriage is, as one same-sex marriage advocate, famous philosopher in this area named John Corvino puts it, marriage is your relationship with your number one person. It's an emotional bond. Children, if any, are incidental to the matter. It plays no particular social role, especially with regard to children. So it raises, of course, the question why the state should be involved at all, since the state isn't ordinarily involved in people's purely emotional partnerships or relationships, such as the relations of ordinary friends or of siblings or what have you. But the key thing to see is this is not a move from a non-neutral to a neutral understanding of marriage in our law. It's a move from one non-neutral understanding to another very different non-neutral understanding. And the force of the law will be used to promote and in some cases to compel acting on that understanding.
The two views you label as the conjugal view and the revisionist view, and you one of the key distinctions you point out throughout the book, that the conjugal view is comprehensive, whereas the revisionist view is based principally on feelings. Could you tease out that difference a little bit? You've already alluded to that, but
Sure. Once again, the conjugal understanding of marriage, the historic understanding of marriage, has been that of the union of husband and wife, and it's rooted in the elementary fact that human beings reproduce sexually. In fact, if human beings didn't reproduce sexually, and there are other creatures that don't reproduce sexually, if we were like them, we didn't reproduce sexually, does anybody honestly think that the idea of marriage would ever have occurred? Of course not. The idea of marriage occurs and is ubiquitous in cultures across the globe and over time. The idea of marriage occurred because human beings do reproduce sexually, and the children who come into being as a result of men and women getting together do not come into being already prepared to face the world like baby sharks who swim away from their mother as soon as they're born. No, they require many, many years of careful care and attention and nurture and education. And so the idea of marriage as the conjugal union of husband and wife emerges, and as I say, is culturally ubiquitous. My friend Maggie Gallagher, who I'm sure you've had on these tapes, makes a very telling and compelling point. She says, when a child is born somewhere, a baby's born, it's a pretty good bet that there will be a mother somewhere in the vicinity. Nature takes care of that. The question is, will there be a father anywhere nearby who will stay together with that mother and help that mother to rear the child, conferring on that child the enormous benefit of being brought up in the committed bond of the mother and father whose union brought the child into being, benefiting from both the paternal and maternal contributions to child rearing. As Maggie points out, nature doesn't take care of that. If that happens, it's because culture makes it happen. And where culture structures its norms and understandings in such a way as to make that happen on a regular and reliable basis so that children are given the benefit of their mother and their father in a committed bond, we have a name for that. And the name for that is marriage. We don't understand